This is News 12 Law Call.
Hi there. Welcome to News 12 Law Call Zoom edition. Tonight, we're going to look at an extremely serious and important topic, nursing home negligence. We have on a pair of attorneys from the Hawk Law Group, one, the founder, Vic Hawk, that has dealt with these type cases, and Sean Merzlak, making the transition from criminal defense to personal injury. Hello, gentlemen. How are both of you?
We're doing great.
Doing fantastic, Neil. Good to see you.
You too, my friend. And why don't we, since the time that we live in, why don't we start with a COVID-19 relation to nursing home negligence? We have an emailer by the name of Jada who wanted to know, Vic, if you can sue a nursing home if they brought COVID patients in and your loved one got sick, I assume, while being in the nursing home.
The answer is yes, you can potentially file a claim, but Governor Kemp has issued a mandate which raises the barrier for you to be able to establish liability. You have to show that the nursing home engaged in willful and wanton conduct. An example of that would be if they brought in a COVID positive patient and put that patient or client in the same room with a person that was negative before. I think that would be a clear example of wanton and reckless conduct leading to potential death or injury from COVID-19.
Okay. And Sean, we often hear this, maybe sometimes with loved ones or people that we know in nursing homes, that sometimes bed sores develop and all. And Frances has a question related to that. Her aunt actually got a bed sore in a nursing home, and then sepsis, which I believe is kind of an infection beyond that. Any recommendations about maybe what Frances' next step should be?
Absolutely. Great question, and one that, unfortunately, many people deal with as you get elderly and you're in this type of community or assisted living facility or nursing home, and your health is deteriorating. A lot of people do have a problem with mobility. What really needs to be done is the family needs to look into what protocols and procedures were going on at the nursing home, whether they, talk with the management and staff there, get copies of the records of the patient, or, contact an attorney about the issue to handle that type of investigation. Bed sores are not always 100% avoidable. They're a pressure ulcer that happens, as we get older, so our health deteriorates as well. So it can be very easy for people, even with the best of care, to at times develop these type of injuries. What we really have to look at is whether there was any negligence on behalf of the nursing home, whether they failed to follow their own protocols for moving the patient. Most have for people that are immobile or have difficulty actually moving on their own, they have procedures in place for the nursing staff and certified nursing assistants to go by periodically and readjust those patients to try and avoid that. There's also a possibility of, a medical malpractice claim if, there were bed sores that became apparent on the patient, and, the proper standard of care was not followed in trying to, fix those bed sores and heal those bed sores. So definitely a lot of things that can be looked into. Unfortunately, sometimes those happen from, neglect or not the best of service in a nursing home. Other times they're just unavoidable.
I was just wondering, for either of you, really, who is the burden of proof on to determine whether that is negligence, since it can just happen? Is it difficult to sort of go after, if you will, a nursing home?
The answer really is very simple, that the plaintiff has the burden of proof of establishing the breach of the standard of care. in nursing home cases, you're going to need a medical expert to review the medical records to establish a breach of the standard of care. And I'll tell all of y'all this, if you're going to pursue a nursing home case, one of the principal defenses raised time and time again is they check to see if these relatives who are asserting a claim for either injury or death of another relative in a nursing home ever spend any time with that deceased relative. In other words, you have a death and the circumstances were avoidable and the nursing home is responsible, but the person who is asserting the claim now for the wrongful death never came to visit the deceased, never had a relationship. So if you have concerns about bed sores, you should be checking on your relative as much as you possibly can. You can take photographs over time to demonstrate what's going on. You should record, and you can record voice conversations with either nurses, directors concerning the care and treatment of your loved one. And you're in a much better position to assert a claim without undermining your credibility if you're the person that cares and loves the person that suffered the injury. It is a collateral issue, but it is one that defense lawyers put into the jury room and the jury considers in determining their verdict. So if you're going to assert a claim like this, including one involving bed sores, make sure you're the person that looks out for the deceased or the injured party.
Sounds good. And Sean, with your criminal justice background, this is an interesting question from Claire. She wanted to know, is it illegal to set up a nanny cam in her elderly father's room in a nursing home? Claire just wants to be able to check on him when she cannot be there at the nursing home. And the nursing home administrator flat out said, no, you can't do that.
Well, that's also a great question, and one especially that's been in the people's minds lately when they haven't been able to go visit their family member that's in a nursing home because of COVID and the restrictions on who's allowed into the nursing home. In Georgia, it's currently illegal. If you're talking about nanny cam, as in like a secret or clandestine type recording, that would be illegal. If it was done with the knowledge of the hospital or the nursing home, then it would be perfectly fine, but they would have to give that permission. It's a private facility that you're renting space in. And if they have a rule that they don't allow that, you have to abide by those rules or find a different facility that would allow that type of thing. There's currently a House bill that's pending and has been introduced the past 2 or 3 years that would make it legal for family members to put cameras in their nursing home relatives' rooms, but it just doesn't get any traction any year.
Well, they do it with body cams in the police, so it might be an interesting step that'll come to fruition down the road. In the meantime, we're going to take our first break, and then we're going to delve into the prescription drug issues and medications in nursing homes and some problems popping up. You're watching News 12 Law Call.
Welcome back to News 12 Law Call with award-winning broadcaster Neil Gordon. And from the Hawk Law Group, attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. Attorney Reed Sanders, born and raised in Thompson and known for his strong courtroom skills. With criminal law, former police officer, now lawyer Sean Merzlach. And with South Carolina injury law, trial attorney Chase Hawk. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Hi there. Welcome back to News 12 Law Call Zoom edition. I'm Neil Gordon. Tonight's topic, nursing home negligence. And in the previous segment, we were talking about how illegal it is in the state of Georgia to have a nanny cam at the nursing home to sort of check up on your elderly family members' conditions. And we bring back in Vic Hawk and also Sean Merzalak. Sean, any other options to be able to check in on how the treatment is going on a loved one if you can't have a nanny cam in there?
Sure. Just like Vic alluded to earlier, the best way to make sure that your loved one or relative is getting good treatment at a nursing home is to visit them often. Not only does that, help them emotionally and psychologically, that's the best way to see how the health of the patient is, whether it's staying the same, getting worse. As Vic mentioned, it's as long as you're a party to the conversation, it's not illegal for you to record the conversations that you have with the facility, the nurses about your loved one's care. That would not be any problem at all. It's also great to, take pictures and make sure you're documenting over a period of time what the health of your family member is.
Vic, does that go back to the fact that Georgia, South Carolina are kind of one-party states where you can record anyone? And this comes up in the media with news folks. You can record someone without them really knowing as long as you're aware. Is that kind of the same rule?
Yes, that's exactly the rule. What gets them in trouble is when they try to use these nanny cams covertly. And the reason it gets you in trouble is there are HIPAA laws that are involved, and there are individuals who are coming in to help the client or treat the client, but there may be other individuals coming into the room because most of these are double occupancy rooms. And so you'd be recording medical treatment, medical condition of other individuals as well at the time you do these covert recordings. Now, the audio recording is treated entirely different. As long as you're doing the recording, you don't have to notify the other party.
Makes sense. We mentioned medications can be an issue sometime in nursing homes. And Sean, Mike is just not sure if his uncle is actually getting his medication on a regular basis. The nurse is saying that she is giving the medications to him, but he says she is not. What can Mike do to verify this, I guess?
There's a lot of options there. Obviously, you can talk to the director of that particular facility and do a thorough interview on the treatment and try and determine if your loved one is getting the treatment that they need and getting the necessary drugs that they're being prescribed. Another good thing, if you can't get anywhere with the facility that gives you peace of mind, would be to contact the Office of Ombudsman. They are a state agency that is basically an advocate for people that are in elderly care units and nursing homes. They have broad authority to go in, talk to the nursing home, get records, things of that nature to determine that. And it's really going to depend on what, the mental state of that family member is. I've certainly, met with many different people that have diminished mental capacity as they age that, don't remember getting their medication and will tell you every single day that they're not getting their medication, and even though they are. So there's a lot of factors that need to be considered there. Obviously, my main concern is if I didn't feel comfortable with my loved one at a particular facility, that they weren't getting the care required, I would be looking for a new facility to move them to.
Good point.
And you got, Neil, I wanted to point out a couple of things there. Think about it from the perspective of proof and trial. Always think about it from not what's in front of us, but what it's going to look like at trial. And obviously the defense is going to say, well, they just didn't take the medicine. We gave it to them and they didn't take it. Or you're going to have them say, well, your father, your loved one suffers from dementia and is just not remembering taking the medications. Well, you can always schedule a private appointment, get a drug test to see if the medications are in the system. And you can also require the director to have some proof by way of a second care provider, some proof by way of a witness to confirm that the medication was given to him and he took it. To know for sure, get the drug test.
Ah, interesting. Okay. One more question in relation to the medications from Melissa, whose mom was apparently misdiagnosed on the wrong drugs for months now on the wrong drugs. And it was only during a second opinion that they found the error. The doctor is refusing to take responsibility for his actions. Does she have a case?
Well, you would really have to get all the medical records together from the nursing home and have it reviewed by an expert in physical medicine or family medicine to confirm whether or not there was a misdiagnosis. And that expert would then have to provide an affidavit for the record when you file a lawsuit against the nursing home to prove that there was a misdiagnosis and as a result, she was given the wrong medication. The problem with that kind of claim is you have to demonstrate a serious permanent injury or death from that particular misdiagnosis, because it costs between $35,000 to $50,000 just in costs for experts to be able to prove your case. And as I tell people, you don't get as much for a scratched thumb as you do for a broke arm.
Well, what happens if a loved one takes a nursing home fall? We'll examine that and take a brief time out and be back with the last segment of News 12 Law Call. See you in a few. Well, thanks so much to the Hawk Law Group for being a community partner on this for more than 8 years, headquartered on Telfair Street, and many ways for you to get answers. You can always dial all fours with a 706 area code. You can go to hawklawgroup.com and get involved in a live chat and also learn about different legal situations online. And again, there's 4 locations, and they'll be happy to certainly help you. We're trying to delve into nursing home negligence on this edition of Law Call. And Sean Lewis has a situation with his grandmom falling in a nursing home. She has had lots of problems since she was hospitalized, and Lewis wants to know if she dies before the lawsuit is settled, does that mean that the lawsuit is over?
Well, that's a good question. And the answer to that is no. Once a lawsuit has been filed, based on activity, negligence that has occurred, the lawsuit can continue even if a party has passed away. Certainly it might, I don't know the facts in Lewis's case. It might change the nature of the lawsuit, might add some additional, might make it an actual wrongful death claim if those injuries that she received in the fall resulted in her eventual death. So it can certainly change what's going on in the case, but that doesn't mean that the case is over. Just like in a wrongful death case, it would be up to family members, a spouse or surviving children to continue to assert that claim, or a representative of her estate on behalf of her estate.
And sometimes there can be even criminal issues that come up in nursing homes. And Vic, this is from Stacy. Stacy's aunt is in a nursing home. She's been getting a lot of bruises. Management's explanations are not adding up, according to Stacy, and she wants to know if it's time to call the police or maybe reach out to an attorney to get this investigated?
Stacy, when you have circumstances like this, I would first contact the state ombudsman. They have full authority to go into the facility, look at the medical records, look at the facility records, look in the room, question the providers, and they can do a really good job of identifying what the source of these bruises are. I know as you get older, a lot of us are on blood thinners and we bruise very easy. Our skin gets very thin and we bruise very easy. So I would use the state office to do an investigation first. And then if they give you information that leads you to believe that there's abuse there, then contact an attorney to help you out with the claim.
Okay, thanks so much. Did we have time for one more? I apologize. Didn't quite hear. Okay, yeah, we do have time for one more question, Sean. This comes from Lisa, who says that she would like to sue a nursing home over her father's poor treatment, but Lisa's sister really doesn't want to. So do they both need to be in agreement for a lawsuit to go forward, or just one?
Well, like many questions in the law, it just depends. It depends on what his particular state of mind is right now and who has power of attorney in the case to act as his representative in a lawsuit. If he is, all, mentally competent still and can make his own decisions, he can make that decision of whether or not he wants to bring a suit. If he is not, and he's already designated a person to be his power of attorney to act on behalf of his legal affairs, it would be that person who would be bringing the lawsuit, while he was alive. If he happened, to die as a result of care, it would be a different story.
Understood, Sean. Thank you so much, Sean and Vic, for the insight. We'll scoot and be back next Sunday with more Law Call.
Thank y'all for watching.